Having established that a duty of care is owed in a number of circumstances, these so-called established categories, where the courts have considered a specific kind of related relationship, such as motorist road users, we're still left with the situation where the law may face a situation where there's a new kind of relationship, and it has to judge whether the defendant in that kind of relationship would owe a duty of care. And that's where we have the second way a duty of care can arise, and that's through a different kind of test. The test isn't really different. It's the kind of the same reasoning that the judges would have used to develop the established categories, only we go back to basics to think about the problem. This test has developed over a period of time. It started with the first element, reasonable foreseeability, which I'll spend a little bit of time on, and then extended to consider other factors. It mainly did this in order for public policy considerations. What they were worried about is being able, for people being too liable in lots of situations. So there are these other reasons that you might not say someone owes a duty, a so-called public policy reason. And these reasons largely underlie the second limb of the test. So if we don't have an established category, and in reality there's many more established categories than what we learn in this subject, so most times it is going to be an established category. But if there isn't, then the courts go to a two-stage test. The first stage of the test is to determine whether it's reasonably foreseeable that the defendant's conduct could affect someone in the plaintiff's position. The second element is, are the salient features of the case consistent with owing a duty of care, sometimes called the multi-factor test. So why don't we get into that now? So what we can see here are the two elements laid out. Really, that the plaintiff must show it's reasonably foreseeable that the defendant's conduct could cause harm to someone in the plaintiff's position. While we have Borehill and Young as part of this, and it certainly is part of the lineage of case histories, really Donahue and Stevenson is the classic case where reasonable foreseeability was really started to be enunciated clearly by Lord Atkins. So that's a good authority as well that we've learnt already in terms of the established category of manufacturer-consumer. So we need reasonable foreseeability, and the second thing the plaintiff needs to show is that the salient features of the case are consistent. So salient really just means that the relevant features of the case. And what they're really saying here, it's not only of this case, but it's of the previous cases. So if we look at previous cases where someone has owed a duty of care, do the features of that case look like our current case? Okay, so do they look the same? Why don't we have a little bit more detail about this? In terms of reasonable foreseeability, what we've got to show is that when the actual act or omission occurred, the incident, that it was reasonably foreseeable. So were we able to reasonably predict that the defendant's conduct could cause harm to someone in the plaintiff's position? This is known quite famously as the neighbour principle, which was set out by Lord Justice Atkin in Donahue and Stevenson. And his actual quote is, "Persons who are so closely and directly affected by my act that I ought reasonably to have them in my contemplation as being so affected when I'm directing my mind to the acts or omissions which are called into question." So what he's thinking about are people who are closely and directly affected by your act. So we have an element of proximity here. Who is going to be affected by the act or omission? We can see this very clearly, for instance, if we're driving a car. So if you are driving a car, then we owe a duty of care to those who are going to be affected by your driving, or who we can reasonably foresee as being affected by our driving. So that would include passengers, other motorists, pedestrians, cyclists, people on the footpath, etc. But one of the problems becomes, where does that end? Where does that reasonable foreseeability end? And the case of Borhill and Young is a great one to help us consider that. So what we have in the case of Borhill and Young is something that looks very close to this motorist other road user, but we reach the limits of reasonable foreseeability. In this particular case, we have a tram which has Borhill sitting on the tram, and actually she doesn't see this occur, the incident occur. Young, who is on a motorcycle, roars past the tram and actually has an accident when it hits a car some 50 feet, or what's that? That's about 20 metres away from the tram. There's a big accident and actually Young is killed. Okay. Now, Borhill gets off the tram, walks past the accident, and then goes into shock and loses her baby, and is arguing that this is attributed to the shock of walking past the accident and seeing Young die. She's also going to argue that Young was riding negligently, which caused the accident. And so that's where we get into this reasonable foreseeability problem, right? So given that Young owes a duty to other people on the road, where does that duty kind of begin and end? What's the reasonable foreseeability? What's the scope of the duty of care? And the court found in this particular case that it's not reasonably foreseeable that someone, if they had a bad accident, could invoke a shock or reaction into someone who wasn't there when the accident occurred, right? Because you've got to remember, Borhill doesn't actually see the accident, etc., and isn't directly involved in it. And that's where we start to get to the limit of this idea of reasonable foreseeability. It is a little more complicated than that in terms of what reasonable foreseeability is, but proximity, or the closeness between the incident and the harm that's being attributed to the incident, is one of the ways that we can start to get a handle on whether whether there is reasonable foreseeability. Clearly, the collision with the car, the damage to the car, the harm to the other driver is reasonably foreseeable. But psychological harm to someone coming around the corner and seeing the incident is further away, more far-fetched, and in the court's view, not reasonably foreseeable. Because there wasn't sufficient proximity between Borhill and Young, Young did not owe a duty of care. An image that might help you think about this is, imagine you throw a stone into a pond, right? When you do that, there's a splash, and then we get ripples further and further away from the splash. So just like that, when there's some negligence, there is an area of impact or harm, and then there are cascading harms or impacts further and further away from the actual incident. Reasonable foreseeability is really closely tied to the direct impact, right? And those things that directly are affected by the act or omission of the defendant. So reasonable foreseeability is quite a difficult area in terms of an understanding, in terms of us understanding in this subject. Think of it as proximity is one way to get there. It's not necessary that you actually have to foresee your conduct could cause harm, just that a reasonable person would. So again, this test of reasonable foreseeability is not what the defendant thought, it's what an objective, reasonable person would think. And it's also not necessary to think that the actual harm suffered is reasonably foreseeable, just some kind of harm could be caused. Once we've shown reasonable foreseeability, we still have to make sure that the salient features of the case are consistent with owing a duty. There's a number of factors in here. Really importantly, one we don't deal with is the fact that courts were worried about something called indeterminate liability, or you just could keep being liable for everything if we ran the chain of events long enough. So one of the ways they get around that is they have a number of factors that they look at to work out whether the case is consistent with owing a duty of care. For our purposes, we're going to concentrate on the control the defendant has and the vulnerability of the plaintiff. So the more control the person, right, who actually had the incident, who had the act or omission that led to the incident, the more control they have, the more likely they owe a duty. The more vulnerable the person who has been harmed is, the more likely they were owed a duty as a result of this. And the case of pair and append is a great one to help us think about that. Pair and append is a great case, and in this particular to understand control and vulnerability. And we've got to think about what's actually going on. So the Western Australian regulations said that your ability to trade in potatoes was affected by whether there was disease on your land or on land adjacent to yours. So imagine that you have disease on this plot of land in the middle, and there are going to be these other farmers with land that adjoins it. So if disease occurs on this farm, the Western Australian regulations are going to say that these farmers can't export or can't import into Western Australia their crops. So this is a particular problem because these farmers in South Australia want to export to Western Australia, so this is all occurring in South Australia. They want to export to Western Australia to sell their potatoes, but they're not going to be allowed if there's disease on this farm, even if there's no disease on their own, okay? Because obviously Western Australia is worried about the spread of disease. Okay, so they're going to say, we have set up a quarantine, there's no export from adjacent farms as well. So in this particular case, append has been negligent in allowing this disease of bacterial wilt on their farm. And pair argues, along with the other neighbouring farmers, that they suffered financial loss as a result of this. Right? While they weren't directly affected, they weren't allowed to export, which changed the price of the crop that they could get. So they're saying the negligence of append affected the economic well-being of pair. And the court held that append did owe a duty of care to pair in this case. It wasn't only about reasonable foreseeability, but the salient features of the case were consistent with owing this duty. Particularly, append knew about the risk to pair. Append had control over the crop and the disease on their land, and pair, because they were just adjacent, they were vulnerable, right, to the negligence that append engaged in. So we see that the company append had control, pair was vulnerable, and therefore the salient features of the case were consistent with owing a duty of care. So just to recap, if a relationship is not in one of the established categories, then to show you owe a duty of care, the plaintiff must establish that it was reasonably foreseeable the defendant's conduct could cause harm to someone in the plaintiff's position. And the plaintiff must also show that the salient features of the case are consistent with the existence of a duty of care. We've been particularly interested in the vulnerability of the defendant and the control of the plaintiff, as in the case of pair and append. So hopefully that's a decent enough summary of the test that we need if we don't have an established category. So if we either have an established category or that two-stage test of reasonable foreseeability and salient features of the case, either of those will establish that the defendant owes the plaintiff a duty of care.